Welcome back, everybody. We're here again, a weekend live. We don't do a ton of these, but the kids are at my parents' house. My wife's out at a girls' night. So I'm alone in the house. So we have some time to talk Ahmaud Arbery. And this case is really interesting. And I did want to look into it, but I kind of let the people decide during the Kyle Rittenhouse live that we did a couple days ago. And this was one of the top 3 cases that people asked to talk more about. So I figured we could jump the gun a little bit, talk about it today. And if it is a case you're interested in, if you're one of the people that voted for it in the live or asked me about it in previous videos, make sure you like this video and subscribe to our page, because if we get enough likes and interest in this case, then I'll do another video breaking down the closing arguments and potentially another one after the verdict of this case. So thanks for coming on this live. I see a couple people in the chat saying they've been waiting for this and they've finally made one of our lives. So we're pumped about that. We like doing it at different times. I know some people have it scheduled every week. They do a live at the same time. My schedule doesn't always allow that. So I like doing it at different times, letting different people that don't always make it into the lives. So I'm happy that we're able to get some people here that haven't been to some other lives. So as we go and talk about this case, and as you could tell from the title of the video, is this case already over? I'm going to start at the end, and then we'll kind of work our way backwards and work through some of the controversial issues of the case. I can give you my thoughts on it. I want to get your thoughts on it. Yeah, all hail King Rose. I didn't say I didn't want to cover it. I did. This is one case I did want to cover. Sorry if it sounded like I said I didn't. I did want to cover it, but I was going to let the people decide either way. I wasn't just going to pick the case I was most interested in. So sorry if I said didn't. This case does interest me. I think it's got a lot of interesting factors to it. But one of the most interesting parts about it is when I started diving in and looking at what happened in the case, because last week I was so busy, I barely saw anything on this case besides the questions in my other videos. The crazy thing I thought and what I saw was them arguing about the jury instructions. So before we get why the jury instructions might end the case, I want to talk to you guys a little bit about how it works in these cases with trial lawyers and how the jury instructions get to the judge's mouth and to the jurors' ears. So the way jury instructions come before a jury is not something the judge chooses to read to the jury. The judge is the one that ultimately reads it to them. The judge is the one that instructs them on the law, but the judge is provided jury instructions by the lawyers. Many times they are joint jury instructions. Sometimes they are not. And the defense will give certain jury instructions and the plaintiff or the prosecutor will give certain jury instructions. So how jury instructions works, there are form jury instructions. We can draft our own specific jury instructions for specific cases. There are some language differences. You can get some from case law and from appellate cases that say this is a good way to read a jury instruction, this is not. We actually, in our last trial, used one that was directly from case law that was a little different than the pattern jury instruction that had been used from the statutes. And that's all okay. But the important thing is we know what the jury instructions are before we start the case. Sometimes we have 1 or 2 that are disputed. Sometimes we have 1 or 2 that we say we'll see which evidence comes out to determine what jury instruction is appropriate for this case. But it's not a surprise to the lawyers as to what the jury instructions are going to be. And I say all that to get to the point as when they're doing the charge conference discussing the jury instructions that are about to be read to the jury, after all the evidence and testimony is done before closing arguments, there's this big argument as to the defense of a citizen's arrest. So let me read here. The arrest by a private citizen statute reads something like this. A private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. That's the first part. The second part is if the offense is a felony and the offender is escaping or attempting to escape, a private citizen may arrest him upon reasonable and probable grounds of suspicion. So apparently the defense was under the impression that that first part, which says the person may arrest an offender that does it within their presence or immediate knowledge, they thought that part was not going to get read to the jury, and it was just if it's a felony and they're trying to run, you can go and arrest them. So I have no idea how a criminal defense attorney, without an agreement from the prosecutor, can just build their entire case around half of a jury instruction not getting read to the jury. They literally said in opening statements, we're not even going to try to argue that the offense was committed in his presence or immediately within his knowledge. We're not even contending that. But what we are contending is that it was a felony and he tried to escape, and therefore they tried to make a citizen's arrest. So he waived that argument in opening. When one of the criminal defendants took the stand, he agreed with that he didn't see him commit a crime. He just saw him running in the street, but he wasn't going for a jog. He was sprinting. He was running away from something. He acted like he knew. But he admitted and conceded that no crime was committed in his presence or within his immediate knowledge. The last knowledge they have an offense committed by Arbery was 12 days earlier or something. So they have waived that defense. Yet the judge said, this is the instruction I'm going to read the jury. That in order to not convict because it was a citizen's arrest, they can determine if it was an immediately acted upon crime or within their immediate knowledge or within their presence, which we all know it's not. So I think this case is over. I think a guilty verdict is coming. I think there's no way they prove a citizen's arrest. And this is my first dive into this case. I have not watched every witness. I've watched clips of some of them. I've read some breakdowns. I've watched some highlights. I've watched them, especially some cross-examination. But watching that opening statement, listening to that defense attorney, and then watching the defendant's testimony, I'm baffled at how an attorney can build their whole case around something that was not agreed upon. It's almost like they thought there was a stipulation that didn't exist. And then some other really interesting controversies has come up with this case. This case has been based a lot more about race than the Rittenhouse case or some of the other cases. I think there's a lot of reasons for that. But maybe the main one is the defense attorneys themselves making it about race, commenting on the black pastors in the back of the room, saying the jury didn't have enough Bubbas or six-pack Joes or whatever he called them, basically uneducated white males. Talking about public lynching and how they might not have had the gallows outside. Just some very cringeworthy statements made in open court by a defense lawyer, knowing the world is watching. Very strange. And then the biggest racial issue, in my opinion, is the jury. And the reason, so it's 12 jurors, 11 white, 1 black. And what's interesting about it is not necessarily that makeup, because I think the community makeup is 74% white, 26% black, something like that. So a quarter of the jurors theoretically should have been black, which I think is 3 out of 12. But what's really interesting about it is the judge and the defense lawyers have both commented on the race of the jury not in the same manner. So the defense lawyer said that comment about uneducated white males, there weren't enough. And the judge said he's going to move forward with this jury, even though he thinks there were major issues in picking this jury as it comes to race. Let me see exactly the quote I wrote down here. There appears to be intentional discrimination in jury selection. That's what the judge said. I don't know how you let a case continue going. I guess he feels it's going well enough for the prosecution at this point, maybe. But if you thought there was intentional discrimination, that is one of the only things you can't do in jury selection as far as striking jurors. If there is intentional discrimination, jurors are protected, so that shouldn't be able to happen. But apparently the judge thinks it did. Then when the defendant took the stand, a lot of the inconsistencies that the prosecutor brought out, I think, were important, especially with the comments made to law enforcement. Some of the comments made by a non-testifying criminal defendant were damning, when he said he was trapped like a rat and if you don't stop, I'll blow your head off. It kind of shows their intent, how they're kind of cowboys, not trained law enforcement, who hopefully would have handled the situation better. The defense attorneys make arguments like, when seconds are important, you couldn't wait minutes for law enforcement to show up. It's like, what? Seconds? When seconds are important. So what did they think they were stopping? At worst, it was a burglary of an uninhabited dwelling. That was the worst. That's bad. And people should get arrested for that. Don't get me wrong. Don't misquote me. If somebody is on property that's private, taking stuff, loitering and prowling, whatever, that's a crime. Call the cops, arrest them, and whatever the penalty is, it is. I'm all for that. I'm fine with that. But to take it to the level of making a citizen's arrest with multiple people armed with guns and end up shooting and killing the person that was burglarizing an unidentified dwelling is way across the line, in my opinion. And that's why the citizen's arrest defense is not supposed to be just loose and used willy-nilly. Okay, this is a very specific defense. And so that to me is way too far. And that's what I thought from this case from the jump. And it seems like the evidence is pointing that out as well, is they were chasing after him unnecessarily. None of them even saw him in the area. As far as what they saw, he could have just been running in the street, yet they were armed, chased after him, cornered him, started a physical altercation with him. And then there was wrestling over the gun apparently. And he ends up dying because of these decisions they made, in making this, a citizen's arrest that they acted like was so important it couldn't wait for minutes for law enforcement to show up. People say I'm misrepresenting the facts. I'm just representing the facts as I heard them in the videos I watched of the trial. I don't know the facts to be anything beforehand. Like I said, I didn't know a lot about this trial until I did a deep dive and watched some of the videos of the actual trial. So I'm taking quotes from the cross, from the opening statements, and from some of the testimony. Let's see what else we have here. I also thought there was a lot of damning quotes that didn't come into evidence, but that went into some of the police reports that were interesting. So, that to me is something that I think could color people watching the trial that aren't that don't necessarily understand that all that stuff doesn't come into the trial. So I think this is going to be really interesting to continue to watch. I'm going to listen through more of the testimony. Monday, I'm going to watch the closing arguments to see the lawyers summarize their cases. But I think it's potentially over just with this jury instruction. So yeah, I hear you, Defid. So yeah, there was definitely prior incidents with Arbery. They were for sure apparently that he had been there before. There were complaints from other neighbors that they didn't want this to happen, but the neighbors testified that they didn't ask the defendants to do this. They didn't give authority to defendants to protect their property with deadly force or anything like that. And that's important in these cases. We'll start questions here with new Chris. If Ahmaud Arbery was armed with a gun and the defendants try to do a citizen's arrest while having that shotgun, Arbery shoots and kills them, is that self-defense? Can he claim self-defense? He can claim self-defense, but it will still be that reasonable person standard we talk so much about Kyle Rittenhouse. And then he could potentially be committing a crime in their presence or immediately before them if he's running in the street illegally with a gun, and if he just committed an armed burglary at that point. So that enhances everything if he's running with a gun. So that's a big difference in this case, in the citizen's arrest, in how the jury instructions are done. But it's a good point. Yes, he could have claimed self-defense, and we would have had to see what happens at that point. But I think it changes a lot of circumstances, not just one. All right, let's see what questions we've got here. Now's the time. If you have questions about this case you want to discuss, if you want to let me know anything about this case, let me know anything to focus on while listening to the closing arguments. Let me know what you think the verdict is. I think the verdict's going to be guilty. So we'll go through it. I'll go through your questions now, and we'll just talk for a little bit. Brand Steele's been waiting on this. All Hail King Rose has been waiting on this. Yeah, I agree. I think this is so opposite of Rittenhouse. And it's really interesting how timing happens and how these cases happen, where we have Chauvin, Rittenhouse, and this case kind of all back to back to back. All different circumstances, different outcomes potentially. And the justice system, people are going to be mad at the justice system, and there are issues with the justice system. I've talked a lot about them on other videos. But I think we're showing that sometimes it can work properly. A lot of times. I think it's the best system in the world. I think we have the best civil and criminal justice system in the world. And I think it's working in each of these cases, and I hope it works in this Arbery case as well, that we can be nuanced, we can look at specific situations, we can look at totality of circumstances, and try to make the best decision and the proper legal decision. Paul from Australia made a live. That's awesome. Hello, Starry. Been very interested in this case in the beginning. Some people think the prosecutor's killing it, the judge is killing it. So Monique, what's up with the strange request on limiting well-known ministers? So there's a couple different ways this can be relevant and irrelevant. They're relevant if they affect the trial. They're relevant if there are outbursts in the courtroom. And they're relevant if they're putting pressure on the jury unnecessarily. The judge seems to think none of that is happening, even commented that there have been no outbursts in the courtroom. But the last one, and what it seems like in this case, is the defense attorney just seems like a lightning rod for this kind of controversy. That's not the only cringy quote he's made throughout this trial. And I don't know if he's trying to get publicity. He did make a motion for mistrial based on his own comments and objections and things he's saying, which the prosecutor then responded, well, isn't that great lawyering? You create an issue and then say it's cause for a mistrial, which you can't do. So maybe that's why. Maybe he's trying to find ways to get a mistrial. WZG, for me, the McMichaels are guilty. Does the offense have to be committed at that moment? No. But here's the point. This stuff is so unusual. It's kind of gray areas. There are arguments to be made based off case law. There's no specific incident of that. But we basically, as lawyers, have to read and break down the statute. So basically, it has to be a crime committed in your presence or immediately within your knowledge. Meaning, you might not be there, but you can watch on your security footage on your phone, right? That's immediately happening with your knowledge. You know it happened. You see him run out. Then you chase him. Wasn't technically in your presence, but it was immediately within your knowledge. Not 12 days before, which was the last time they knew he committed a crime. Then they saw him running. Okay, because the one guy that actually saw him in the house, who also grabbed his gun, called 911, actually called the non-emergency hotline. That was immediately within his presence and knowledge, but not the three defendants. So it doesn't have to happen at that moment or with your eyes on it. Somebody got mad at me and objected to my clapping or snapping to make my point, so I apologize. Yeah, people saying how the defense was citing case law from the 1800s. Not true at all. The media made it about race. The media does that. The media does that a lot. In this case, I will tell you, I have almost never heard in court or in any cases the type of comments and quotes made by the defense attorney that I watched with my own eyes and listened with my own ears on YouTube in the courtroom, listened to him say. So it was strange. It was very strange. I'm sure the media is blowing it up and stuff too. Again, I haven't been following a lot of media on it. I'm not saying the media is not doing that. I'm just saying the weird part about this one to me is what the defense attorney is saying. And NPR said he heard a phenomenal attorney. He very well could be. That's why I don't come on here and say this attorney is incompetent or this attorney is the best attorney in the world. If I don't know and I haven't seen him in person, I'll talk about what they did in this case and what I watched, but I can't necessarily comment on their entire career or what they do for everything. The defense attorney never invited civil rights activists in the gallery. Correct. He didn't invite them. He asked for them to leave or not come. He doesn't want more black pastors, I believe is what he said, or people like Jesse Jackson, something like that. That's what he said. And you can listen to all of it. You can listen to him say, this is not him being misquoted. He's even apologized for some of them. Tammy Tungett, is it possible the defense lawyer was trying to sabotage trial for mistrial? That's what some people are saying. It was funny because in the Rittenhouse trial, some people were saying the prosecutor did that. In this trial, some people were saying the defense lawyer is trying to do that. So you can see how lawyers know the rules. And we understand sometimes when certain rules will be more beneficial to us or less beneficial to us. It doesn't necessarily matter what side we're on. The rules are part of the process. This is starting to sound like a railroad job. What do you mean? From the prosecutor or from the judge? I'm really shocked that any defense attorney would waive a defense before knowing it was stipulated to. That's what's really shocking to me. Alana, I probably would have turned in any case, but I'm glad this one was chosen. Thank you. Yeah, and there's been so many motions for mistrial. And here's the problem. In Rittenhouse, people said the defense attorney should do it more. In this case, they say the defense attorney should do it less. There's two reasons to do a motion for mistrial, which we've talked about. One of them is to get the mistrial because something's happened, but the other is to protect the record for appeal. So doing it a lot could mean he's bringing up a lot of issues for appeal. It sounds like they're definitely going to appeal, and they're creating all sorts of issues and pointing out all sorts of issues that could potentially make this case appealable. I'm interested if there's an email or something with the prosecutor saying, yeah, that first part of the statute's out. We're just going to build it off the second part too. Then they go back on it. Judge agrees with them. Then potentially there could be a mistrial if the prosecutor's violating some agreement they had with the defense attorneys. I'm not saying that's happening. I'm just saying that would be more plausible as to how it could be such a big swing and a miss. They were in the Army, weren't they? The one that testified, I know, was in the Coast Guard. I'm not sure about the other ones. DFID, Greg McMichael killed their chances of defense. Let me know what you mean by that. Expand on that. I want to hear what you guys think about what you've watched so far. Zero evidence he stole anything. That's correct, and that's not even the point. They don't have to prove, for the defense, they don't have to prove that he stole anything because, and I saw somebody else say he didn't break in. Oh, here it is. Wait. Oh, ever try to break? Somebody else said he didn't break into the dwelling because it was open and it was a construction site or something. Burglary, if there's an open window in a private property in a house and you're not allowed to be on that private property and you stick your hand into the open window, it can still be burglary if you're breaking in to that person's house, right? You don't have to actually break a door or anything like that. It's kind of like breaking an invisible line. So he technically could, because of the videos, so it seemed he was on this property, wasn't allowed to be. It could be potentially burglary. You don't have to necessarily steal anything for that. We're getting into nuanced criminal law, but that's not what's important. The point is, it didn't happen with immediate knowledge or in their presence, and they still chased him down and shot. Hello, Marlene. So Diana Rose, but why does that stuff not go into the trial? The rules of evidence are set up in a way to give everyone a fair trial. Certain facts are either not reliable or not relevant. And if you make certain witnesses or defendants or parties look bad based on things they say that are not relevant to the actual case and their actions, then we could be convicting people of just being immoral or being unlike us or saying or doing things we don't like, whether or not it's illegal. So that's why certain things don't come in to trial, even though some of us on the outside, not lawyers, but some lay people on the outside listening may think it should come in. The jury should know this. This should, help them understand. Some people think the jury should know what the potential sentence might be, because in some of these drug cases where they're going to prison forever, jurors maybe would acquit them, but that's jury nullification at that point. Or if they knew it was such a light sentence, maybe they would convict them because they feel bad for the victim. So there's a lot of reasons the jury doesn't know stuff like that, and the reason the jury doesn't pick the sentence in most cases. So the McMichaels were armed along with cops 2 weeks previously looking for Ahmaud. The cops were fine with the assistance. I did not see that. Wouldn't change my opinion on the case. They should have waited for the cops, if anything. That doesn't make sense to me. This will be surprising, but maybe you're right. I'm not going to say you're not right because I haven't read everything about this case. Peebo, yes, I do. I'm sure people disagree with me. I'm just saying, in my opinion, I think it's the best. And I've looked into a couple different countries and how they do things as well, and I do. I think ours is the best. We have plenty of issues in our justice system as well. So some more cryptic quotes from DFID. I was sympathetic to Michaels, but someone shared something and it changed my mind about things. Carrie, on a side note, from the last couple of trials, only people thought before they acted. These guys have ruined their life due to lack of thinking. I agree. Being well thought out can really help with a lot of these cases on both sides. Everybody's thinking. If we're a little more well thought out, then I think we'd be better off. Yeah, he never broke in, someone said. So I answered that. I am back. Marlene Brown, what I learned from the Rittenhouse case is how much the media twisted and lied about what happened in Kenosha. I see DFID posting a couple times, wow, and from the judge. I'm not sure what you're commenting on. Let's see here. What else we have? Leaf Saniger, I don't always agree with you, but thanks for the honest answers. Thank you for being here. Honestly, I had somebody, talk about other lawyers talking on YouTube and how I disagree with them, so we could never be on a channel together. I'm like, I'm fine with people disagreeing with me. I like having conversation. I like having nuanced conversation and differing opinions. And I think we learn more and it breeds good conversation when people disagree. So I'm more than fine with you disagreeing with me. I would love to hear your questions and hear your opinion on it. I probably won't always agree with you, but that's welcomed on this channel. Respectful disagreement is always welcome on this channel. And you can see I post comments from all different people that, feel differently about each case. And I think it's interesting. And that's why we all get to kind of talk together about this. Brianna, how come the judge puts the conditions of a citizen's arrest in the hands of a jury? Can't the judge strike citizen's arrest from the instructions? He could theoretically, if he found that as a judgment of matter of law, it couldn't be a citizen's arrest, which is a good point. Because the defense waived it, theoretically he could grant a directed verdict on that. We'll see if he does. It doesn't seem like he's going to at this point. He's just going to let the state hand it to the jury and explain to them that it, couldn't possibly be found. And he said he understood the gravity and weight of his decision. But this is a good, intelligent thought by you that if the defense already waived half of this, how possibly could a jury convict or fine for a citizen's arrest? But the defense could maybe argue in closing that some facts came out that actually 12 days is immediate. They could make some arguments like that, see if the jury picks up on a citizen's arrest still. So at this point, it seems like he's going to let it go to the jury. But this is a good point by you. Well, the issues with the defense get them appeal. I think they're going to appeal. Now, the question is, will they win? What you can do legally and whether or not you're going to win are two different questions. To me, I haven't seen anything. Again, I've not watched every second of this trial, but I haven't seen anything that's come big enough to be an appealable issue. Is it Andrew Sanders? Is it common for lawyers to intentionally do something to force a mistrial or just when they're trying to ride the line of what's allowed? It's unethical to force a mistrial. You can get sanctioned and potentially thrown in jail. You can get disciplined by the bar if you force a mistrial. You can be sanctioned the costs. So like if you force a mistrial, a ton of cost goes into every trial. So if there's a mistrial, it's not just like, okay, we start over in 3 months. Everybody's got to get paid again. All the court staff, all law enforcement, all experts, all lawyers, everybody gets paid again. It's a huge waste of time and money. So that's the major issue with it. So no, it's not common at all. Correct. That was an actual quote. Yeah, can't do it on purpose. Defid, you're right. I think it tells what their mindset is. That's why it's important. All right, let's see here. So this is interesting. Did the prosecutors have an advantage questioning Travis? They broke for the day midway through. She returned the next day extra time thinking about testimony. So this is random a lot of times. When they're going to break, we break for different reasons. Sometimes it works out great for us. Sometimes it doesn't. Sometimes we go right into closing argument after doing 4 witnesses, which is tough. Sometimes we get to regroup, go home at night, look through everything that was said, and better prepare a closing argument. It's good sometimes for cross. I know when our client is on the stand, especially in like plaintiffs' cases, we want to get them all done at one time. We don't want a break like this to happen. So maybe there was an advantage, but I don't think it was an unfair advantage. And it happens in tons of trials because a lot of times you just can't control the schedule all the time. So yeah, all hail King Rose. I think I answered the burglary part. Most states, yeah, you have to actually be trespassed, which means told you can't come back. You trespass somebody, then they come back, then they can get arrested for trespass. All right, sorry. I know jury knowledge was talked about a lot in the Chauvin and Rittenhouse cases, regardless of how the jurors were selected. Are these jurors capable of being fair? It's a question that comes up in every case, especially high profile cases. We hope that the jurors were fair. All we can do is ask them questions. Now, in state cases like this, we get to dig in a lot to see what their potential biases or prejudices may be. So hopefully it was a jury capable of being fair, but the judge has really called into question, I think, the I don't know, the fairness of picking this jury. WZG, I would love to. Be more than happy to go on there, but he's the big shot. We've reached out to him. He hasn't got back to me, probably because he's super busy and a ton of people are reaching out to him. So if the invite ever comes, you'll see me on there. All right, let's see here. All right. Thank you, DFID. See, we even had some disagreements early on, and it's fun, man. We get to talk through it. All right, so some people think it's justified because Ahmaud Arbery went for the gun. Disagree. That is not the same thing. But it's okay. People can disagree. We'll see what the jury ends up. The Virginia farmer, I do think they will be found guilty in this case for a bunch of reasons, mainly because they blew their affirmative defense of citizen's arrest, in my opinion. Interesting thought is, will they have an ineffective assistance of counsel claim for the appeal? because I've never seen this done by a lawyer before in a case like this. So some people are posting in here, Ahmaud was on probation. He had prior gun charges. A couple things. Number one, that doesn't matter as far as whether or not he's committing a crime today, because then that would be every criminal or every convict or person that had committed a crime in the past. That means that when you come on them, you can come on them with a gun and potentially shoot them. That's not how our system works. Number one. Number two, if they really felt he was armed and dangerous, and in their neighborhood, what would a reasonable person do in that situation? Not grab your guns and your three best friends and jump in a pickup truck and chase after him. That's why you call the police. That's why you call law enforcement. That's why we have this type of system in place. And I think that that's important to remember is, oh, they knew he was dangerous. They figured or assumed he was armed. That's not how this goes. That's not how the world works. That's just not appropriate or justified or has any legal justification in my mind, because if you see somebody running through your neighborhood and you think that this stuff is happening, you call the cops and you wait and you tell the cops what you saw, you give them the information that you have, and that's how the system works. And if you want to chase after this guy, go become a cop, in my opinion. New Chris, they got arrested after the video made news. If they wouldn't have videotaped it and gave it to the cops, they maybe would have gotten away with murder. Not just that, but there was all sorts of weird stuff with the prosecutor in this case and not wanting to prosecute them because they knew somebody, and now she's getting indicted on charges. A lot of weird stuff happened in this case. A lot of weird stuff. Melissa Remlinger, what do you think about the prosecution getting admonished by the judge about the question that they asked the minor witness? Something like, you agree it's not worth it to kill somebody because they're stealing, something to that effect. I think that I think it was appropriate for the judge to admonish the prosecutor. That happens more than you would think in trials, for them to say, take it easy, Miss whatever, take it easy, Mr. Tragos. Take it back a notch. The last trial I just had, I was objected, badgering, argumentative, standing up and screaming the lawyer at me, and the judge overruled it every time. And my questions were a little argumentative, but they were necessary because the witness was kind of arguing with me. So the judge kind of just makes those calls in the trial depending on what the cases are. Can you compare this case to the Rittenhouse case? The first and most important factor to me is Ahmaud Arbery, for all intents and purposes, was running away. Call the cops. Hope they can find him. If not, you see him again, call the cops. See if they can find him. Let him do an investigation, right? The Rittenhouse case, to me, was different because it seems like, based on the evidence in the video, he was being pursued and people were physically and verbally threatening him. He was hit and kicked and people reaching for his gun. That stuff happened to Rittenhouse. Arbery did none of that. McMichael on the stand even testified. He never verbally threatened me, never physically threatened me. I was not in fear for anything until the gun tussle happened. But so none of that was happening while they were pursuing Arbery, which is what the media told us Kyle Rittenhouse did. The media told us that Kyle Rittenhouse chased down and gunned down unarmed men and shot them in the back as they ran away. That's what was told to the public. So that's some of the differences I see in this case and the Rittenhouse case. Yeah, people saying one of them was an ex-cop. That doesn't matter. If you're an ex-cop, you know more than anything that people that aren't cops shouldn't be chasing people down in the street with weapons. J.O. Gomez. In my opinion, this is nothing like the Rittenhouse case. These guys are boned. They chased an unarmed man with a shotgun and killed him when defending himself. Yeah, Vanessa, I'm not going to put that on the screen, but that is some of the stuff that's not coming into evidence, but I think is things some people think is relevant in the case. But I think the prosecutor was smart and the judge were smart not to let it in because that could be an appealable issue, and I think they can win without it. So if I'm being robbed and fight back and get shot, the Second Amendment will allow the robber to go free? No. I don't know where you're going with that one. Police body cam of him dying and no assistance or CPR. There are so many videos and pictures in this case that are just miserably horrible. Horrible. Yeah, don't watch the media and just go with the facts and the law. It's good. All right, so PTARK, who would try to grab a gun when someone is pointing it at you and you know they're probably trying to kill me? Who wouldn't fight off? And I'm not sure I fully understand the question. I probably wouldn't try to grab somebody's gun if a few guys were standing around with guns around me. I probably would just stay there, but who knows why people do what they do in certain situations. Aloha from Hawaii. I'm not sure if we've ever had somebody from a Hawaii comment on here before. All right. Let's see. Any other questions in here? Most victims fight off the aggressors, maybe. Yep. Billtown biker Ahmaud knew what they were doing. There was a Confederate flag on the front license plate. He knew it wasn't to invite him for coffee. I think that's where race and a lot of this can come into play too, is what he was thinking would obviously be different than what I was thinking. So that makes sense too as to why he tried to grab the gun, fight him off, whatever it may be. Humperdinck, do I know if the citizen's arrest is popular in the South? It is not. The citizen's arrest is not popular anywhere. It really is not. And that's why I would be surprised if it worked on a case like this. Yeah, I agree. Everything is photogenic. I'm not one to racialize everything, but relevance of race is very clear in this case. I agree. And people are going to be annoyed at it and mad at it. And that's another thing of the media. It does a disservice to try to make everything about race if, certain things are and certain things aren't. This absolutely is, in my opinion. I don't think everything is personally, but Micah, yep. Everybody like and subscribe, please. This is our first Ahmaud Arbery video. We've talked through why I think the outcome is going to be what it is, why I think the case could already potentially be over, even though we haven't gotten closing arguments yet. If we get enough likes and comments, it seems like enough people are interested. We've got almost 300 people here on the live. So I'm going to watch the closing arguments as much as I can, and then I'll do a video after that. And then whenever the verdict comes down, we'll do a video of that. So at least 2 more probably Arbery videos are coming. It's one of the highest voted voted video or case in the last video that we did. There's still 2 others that are contenders, so we'll keep an eye on them. But yes, please subscribe, please like, follow our channel, come get involved in the comments, get your questions in so we can talk through, especially in the chat during the lives. Brianna, that's correct. I hope none of you encounter a group of vigilantes out to get you for a walk or a jog. I agree. I hope none of you get in any of these situations that we talk about in any of these cases. Some of it can be with your decision making, some of it you have control over, some of it you don't. But we all hope none of us get in these situations. What kinds of things truly justify a citizen's arrest? So, just speaking in hypotheticals, and we talk about it in law school, if you come across somebody that's physically hurting somebody, raping a child that can't defend themselves, if you find out your neighbor is locking women in their basement, that's a situation where you can make a citizen's arrest, kick in the door, even go in guns blazing, not blazing, but armed, and do what you can to stop that because you're stopping physical harm from continuing, right? You almost never should pursue someone. I know in the statute it says if they're fleeing, you can still make that arrest, but it better be for something huge, not walking around property you shouldn't be walking around. So there are certain things that justify citizen's arrest, but I don't think this is one of them. So fake that guy was not jogging. Yeah, I'm not saying he was jogging or was not. Some people have said he was, some people said he wasn't. It seems like he was absolutely not jogging from the testimony of the guy that saw him on the property. He took off running. But the importance, the same thing with the Rittenhouse case, is what's in the mind of the defendants. They did not see him burglarizing that house. So from their perspective, he could have been walking, could have been jogging, could have been running away from doing a crime. None of which justify chasing him down with guns and eventually shooting him, in my opinion. But we'll see what the jury says. We'll see what the jury says. H. Easton, I did this in the beginning, so I'll try to do it quick. Basically, the prosecutors have been winning most of the arguments in cross-examination. The defense have been making some strange, cringeworthy arguments, but the biggest thing that's happened so far is the defense has been arguing just half of the citizen's arrest statute. They basically waived the first half and conceded the first half, that no crime happened immediately or in their presence or within their immediate knowledge. They basically conceded that in opening and throughout the trial, and they focused on the fact that if a felony is committed and somebody's trying to escape, then you can make a citizen's arrest. And the judge said he's going to instruct the jury that both need to be true for a citizen's arrest. Yeah, Isaac, I think you've asked a couple times, how can the media get away with such blatant misrepresentation of the facts? Isn't there a point where freedom of the press becomes intentional misinformation? Everyone from both sides seems to be arguing this stuff. That everybody from the opposite side is spreading fake news and misinformation. Jay Farr, can you explain if self-defense needs to be in a reasonable level of threat? Yes, it's a reasonable person standard. So what a reasonable person would do in the circumstances of the defendant. So somebody that was going through what the defendant was going through with the knowledge in their head that the defendant knew, and that's important. In Rittenhouse's case, and in this case, it's important. What did the defendant actually know at the time? Not what they know now after watching videos and reading transcripts and seeing and listening to testimony, but what did they know at the time? That's whether or not it was reasonable. You heard what happened in Wisconsin today. Could be related to Kyle's case. Man, it's crazy. I did not hear. Yes. So new Chris. A couple people have brought this out. And the comments, the racial slurs that Travis McMichael made didn't come in. I've already kind of gone through as to why. The judge felt that it was more prejudicial than probative and not as relevant to the situation since it happened after the fact. But basically, why I think that didn't come in is the judge didn't want to create a potential appealable issue because that is so prejudicial. And they, frankly, the prosecutor didn't need it to convict them. I don't think. We'll see what happens. But that doesn't come in a lot of cases, but it also came in some other side reports. I don't know if it's as admissible, or what's the word I'm thinking of? I'm slipping my mind as to why certain things can't come in because they're not as like provable, but I can't remember what the word is now. It's slipped my mind. Oh, a car plowed through a crowd in Wisconsin? That's terrible. A bunch of people got hurt. Holy cow, it's terrible. A red SUV through a Christmas parade. Oh my gosh. Man. Shelby, how do you prove what they knew at the time? Is that more of a feeling? No, that's what they're trying to prove is like with Rittenhouse cases, a lot of things didn't get to come in that were videoed or said or recorded because that he did not know it personally. And that's why the prosecutor tried to keep certain things out. Like you didn't get to hear what Rosenbaum's prior convictions were because, even people were trying to be, oh, he was disgusting. He was this convicted felon, pedophile, whatever. Kyle didn't know that at the time, so it would not have entered into his mind that this person could be potentially dangerous. So that stayed out. There were a bunch of things that stayed out. So there has to be some evidence that the defendant knew it at the time. And one way you can get that in is with the defendant testifying. So PTA, so those comments, it's not just that they're not relevant, but there's a standard in evidence that you have to weigh. Is something more prejudicial than probative? And will it inflame the jury, meaning make them so angry as to disregard the law and make a decision based off that? So sometimes we have to be careful in the laws, what we let in trial and what we don't. If I was the prosecutor, I would argue it's definitely relevant. But if I was the defense attorney, I would argue to keep it out because they're going to convict him for saying that, not mattering what he did. So if something's more prejudicial than it is probative, meaning to prove a fact or disprove a fact, then sometimes it stays out and the judge has to weigh that. Yeah, it's not probative. It's reliable. It's a simple word. It's reliable. That's what I was thinking of. Like hearsay can't come in because it's not as reliable. And there was something about that comment that I was in a report. It's slipping my mind now, but that maybe makes it less reliable than if it was in the initial investigation or if it was actually heard and audible and positive based on the audio and video recordings. I'm not sure, but I think there was some argument about the reliability of it. Reliable. Thank you, though, Alana, for trying to help me for the words slipping my mind. So Jay Farr, I did see they were charged with a federal hate crime. I don't know what's going on with that right now. Are you ready for the Chad Daybell case? Is anybody really ready for that case? I'm ready for it to start and to learn what actually comes out in trial. That's always what's so fun about these cases, not being intimately involved. Like, I know what's going to come out in my cases that I take to trial, but when the case is not your baby and you're relying on the media and people to talk about it, it's really fun to see what actual facts come out of trial, that the jury's going to make their decision based on just that. So I like to kind of wipe my slate clean, watch and dig into what actually comes out in trial and break it down and make projections based off that. And a shooting involved in the car accident. It's the type of stuff that I don't know if that's related to Rittenhouse, but it's like, this is stuff we were talking about before. Somebody made the comment of we need to be good decision makers. That's just not, how does that help literally anybody? All right, let's see. Cops were called a couple of times, missed them each time. That's correct. And that happens. That does not give us license to go out and do this stuff ourselves. It does not. Yes, Marlene Brown, prayers for those people involved in that shooting / car accident. That's terrible. American law is so weird. Yeah, so I'm seeing a lot of comments about a certain case I'm not going to comment on now as to whether or not that was in the running for the two cases we may be breaking down. But why not? The Maxwell case related to the Epstein case is probably one we're going to be looking into. I think that's going to be long. That's going to be difficult. It's going to be interesting. We will probably end up doing some videos on that. So if you are interested, stay tuned and make sure you subscribe. Make sure you post on our other videos that you want us to do that case. If we do any polls, vote for that on our community page. I think it's federal. I haven't dug into it yet, but I'm pretty sure it's federal. If it's federal, it's not going to be televised. So we'll have to get our information from other sources, which is always difficult, but we do our best to get solid information and bring it to you and break it down for you. Lady C, yes, I talked about this a lot in the beginning, so I don't want to rehash it. That was my light. I talked about this a lot in the beginning, so I don't want to rehash the whole thing to bore the people that were there for that. But if you just jump to the beginning of the video, we talk a lot about this and about how I think it was really weird. But we'll see. All right. We're getting close to the hour mark, which is usually where I like to call it because I don't want to bore you guys. I'd rather you want to come back for more later. So if you haven't already, please subscribe to our page. We're going to hit more of this Arbery case. We're going to, because I'm making the executive decision here myself because there was enough people interested. The chat was fun. The questions and comments were fun. And we are going to also probably talk about that Maxwell case. We're going to do more about some other cases. So make sure you stay with those alerts on and make sure you like and subscribe and all that jazz. But this was fun, guys. Thank you so much for coming and joining me again on this Sunday night. We will all say a prayer for everyone involved with the car accidents and the shooting and whatever's going on in Wisconsin now as we follow what's happening in that story. But as always, you guys are the best. Thanks for joining me last minute and making this fun and making this hour fly by. So until the next time.